The next case this morning is Vega versus Grafton Correctional Facility. Each part will have 15 minutes to present an argument. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
I don't think I'm going to use my whole time, but I'll use 3 minutes for rebuttal,
very
just in
good.
case. Thank you.
If you do, when you do reserve time, I will try to give you a time warning about a minute left, just so I keep the time up here. The arguments are being recorded. When you come to make your argument, please introduce yourself. Make sure you stay behind the podium because we are video recording you, and we lose you if you go out from behind the podium. And please make sure you speak in a loud voice so we can hear you on the recording. You do not need the name of a child, minor, or victim in this case, although I don't think it really applies for us in this particular matter. With that, we read your brief and are ready to proceed whenever you want.
Thank you, Don. Good morning, Your Honors. May it please the Court, Counsel. I'm Tom Saxer. I represent the defendant at the trial court, the appellant today, Grafton Correctional Institution. As I indicated, I'd like to reserve 3 minutes of my time for rebuttal. Revised Code 412301C establishes that there are 2 requirements that must be met for a work injury to be compensable under the workers' compensation system in Ohio. First, that injury must be incurred in the course of the employment. The second requirement is that the injury must arise out of the employment. In the course of has been defined as the time, place, and circumstance, and there is no dispute that Ms. Vega was in the course of her employment. She was on the clock, so to speak. She was at our facility, and she was walking from her office to a copy machine to make a copy of an email. The issue here is whether her injuries arise out of her employment. The arising out of element requires a causal connection between the injury and the employment. It has been explained that to arise out of, the injury must be caused in substantial part by the hazard of the employment. This court addressed this issue in the Tamarkin versus Wheeler case. This court held that the purpose of the Workers' Compensation Act is not to make an employer an absolute insurer of the employee's safety, but to only protect the employee against risks and hazards incident to the performance of his work. When you review the record as a whole, Ms. Vega does not meet the second prong. Her injuries do not arise out of.
Well, she said, my understanding was that it was a busy day and she was rushing because her employment duties required her to rush, basically.
That was her deposition testimony. I think if you look at the video, I don't think she was rushing as she walked through the reentry room. She relies heavily on 2 cases that I want to address because I think they're both distinguishable. The first is the Waller case. I think the key to the Waller case is it dealt with an unexplained fall. At page 122 of that decision, the court noted an injury caused by an unexplained fall presents a unique case under the workers' compensation laws. At page 124, the court continued, under the circumstances presented in the case here, where it may be shown that the unexplained fall resulted from a neutral origin, this court adopts a view that an inference will arise that the fall is traceable to some ordinary risk, albeit unidentified, to which the employee was exposed on the employment premises. That quote is followed by a footnote at the end of the decision, footnote number 5, and that says this is not a novel doctrine. This rule in unexplained fall cases is established in English cases, and then the footnote goes on to explain the history of unexplained fall cases. Waller, though, is factually distinguishable. We do not have an unexplained fall. Therefore, there is no inference that her fall was caused by some unknown risk associated with her employment. We know exactly what happened, and we know why she fell. Respectfully to Ms. Vega, she tripped over her own feet as she came through the reentry room, and the video that we have filed as part of the record, it's item 22, clearly shows that. They also rely heavily on the Griffin case. They cite to the Griffin case at page 7 of their brief for the proposition that, and I quote, absent an idiopathic cause, plaintiff's on-premise injury is compensable as a matter of law. That is just too broad of a statement. That would essentially eliminate the arising out of element from 412301C, and it would make the only requirement in the course of, which relates again to time, place, and circumstances. But Griffin is factually distinguishable. Griffin occurred when Ms. Griffin, who was working for GM, was leaving the plant at the end of her shift. She's walking to the parking lot, has to cross over a driveway. She slips on ice and she falls and she gets injured. The focus on Griffin was whether or not that court was going to apply the special hazard rule that had been articulated in the Littlefield case. Littlefield involved a coming and going case where a gentleman was driving into the plant, had to cross, make a left turn over traffic to get into the facility. Griffin case so distinguished Littlefield because it happened on premises. It said, in contrast to Littlefield, this case involves an injury sustained in the course of employment. Upon the employment premises, it involves a hazard, which by definition is unique to the employment cited. So the Griffin court clearly found there was a hazard present. It was the ice upon which she slipped and fell. The Griffin court just didn't require that it be a special hazard in order for her injuries to be compensable. And the Littlefield court had defined special hazard as being distinctive in nature or quantitatively greater than the risk common to the public. All Griffin did was eliminate the requirement that it be a special hazard as opposed to just a hazard. It did not eliminate the requirement that a hazard still be present as is required under the arising out of element. I think it's also important to note that in that Tamarkin case that this court decided that held the employer is not the absolute insurer of the employee's safety, but is only to protect the employee against risks and hazards incident to the performance of the work. That Tamarkin case was decided 4 years after the Griffin case was decided. So Tamarkin clearly shows that Griffin did not eliminate the need for a hazard. It just eliminated the need for a special hazard, and Tamarkin confirms you still have to have that second element to have a compensable injury. Here, I think the record is clear. There was no hazard. There was no risk as she walked through the re-entry room. Plaintiff's own testimony, her deposition is item number 26 in the record. I would refer you to page 25. She testified she did not trip over an object, furniture, chair. She testified that unlike Griffin, there was no substance on the floor. Again, Griffin had ice that she slipped on. Ms. Vega confirms on page 25 there was no substance on the floor. And Ms. Vega confirmed at page 25 there was no defect in the floor. The lack of any hazard is evident from the video. Again, item 22, I hope you will watch that video. You will see she enters the room from the right. She's about 1.5 feet, 2 feet to the left of the table and chairs. She doesn't, as she indicated, trip over anything, and it's clear. She catches her toe, and she stumbles forward. In fact, a couple minutes before that, you have another employee who enters from the left and walks through the same room on the same path as Ms. Vega did. Walks right through the room with no problem. There is no hazard, there is no risk.
Counsel,
Yes?
in terms of determining whether this is arising out of the employment, so the trial court granted summary judgment after reviewing the tape.
Yes.
So is whether it was arising out of a legal question or a factual question?
I don't think there's any factual dispute. I think everybody agrees that she was walking through the room. There was no hazard, there was no substance, she didn't trip over any furniture. I think everybody agrees. It's a little bit of semantics. She says the floor grabbed her foot. We think the video is clear that she just caught her toe as she was walking through, didn't lift her leg high enough to not catch her toe that morning. I don't think there's a factual issue that the jury would have to determine. I do think it's a legal issue as to whether she meets those two requirements. Does it in the course of, and we concede it is in the course of, but arising out of, and again it goes back to the Tamarkin case, hazard and risk associated with the employment. I think if you look, Your Honor, at the trial court decision, it's on page 6, I think you see where, from our perspective, where the error is. The trial court only addressed, when you analyze the decision, really only looked at it in the course of. Under conclusion, page 6, because it is undisputed that Vega was performing her job duties at the time she was walking to the employer scanner, reasonable minds can come to but one conclusion in this matter. The fact that Vega could have tripped and fallen anywhere doesn't change the fact that she was injured while performing her job duties at Grafton Correctional Facility. All that does is confirm she was in the course of time, place, and circumstances.
What does the circumstances relate
I'm sorry?
Your test, time, place, and circumstances, what are the circumstances?
Circumstances is that she is walking from her desk to the copy room to make a copy. That is in the course of, and that is all the trial court analyzes. The marking clearly says that the injury has to result from a risk or hazard associated with the employment. The trial court never addresses that. The trial court never identifies what risk or hazard she encountered. If there was a substance on the floor, perhaps, but she testified there wasn't. If there was a defect in the floor, a loose tile, perhaps she has an argument. She testified there wasn't.
Is this carpeting?
No, it was tile.
Well, the trial court does mention the need for the causal connection when it analyzes the arising out of element.
Well, respectfully, it says it. It doesn't give any analysis to, and I go back again, when you talk about arising out of, it is a separate and distinct element, and it requires some identification of risk or hazard. And while the trial court puts the words on paper, it doesn't give you any indication of what the risk or hazard was. She's merely walking through the room and she catches her toe. There is no hazard, there is no risk. We think that is the error of the trial court. It only analyzed 1/2 of 412301C, and it never got to, although it says it, it never in reality in analysis got to what was arising out of, what was the risk, what was the hazard. And by failing to identify the risk or hazard, we believe that's where the trial court erred. We believe the record is clear. I don't think there's any issue of fact. That's why we had stipulated that we would do it on cross motions for summary judgment. Everybody agreed what the facts were. It was just applying the law to those facts. And I think in failing to address the arising out of and analyze it and identify what risk or hazard Ms. Vega was confronted with that day, I think the trial court erred. I think the record's clear there wasn't a risk, there was no hazard. She merely walked through a room and caught her toe.
Well, to Judge Cart's earlier question at the beginning, there was some testimony that she was rushing, and your response was, if you look at the video, she's not rushing. That's not a question of fact?
Perhaps.
You have 1 minute left, counsel.
Okay. I think for the reasons articulated, there is no reference to any hazard or any risk. We think the trial court erred. We would ask you reverse the decision and a judgment in favor of Grafton. Thank you.
Thank you. You'll have your full rebuttal time left.
Thank you, Your Honor. Appreciate it.
May it please the court, counsel, Nancy Vega. Your Honors, good morning. I'm Christopher Winside on behalf of Nancy Vega. And I will try to address all the various arguments that have been made by Grafton's counsel. Before Griffin versus Hydromatic became the law, we had developed a clutter of tests based upon innumerable fact patterns. And so the test would have to be designed, for instance, little field, or sports injuries, secondary to perhaps accompanying picnic, etc. And there had to be both elements established. One is in the course of, the other one is arising out of. And that's always been the law, but when Griffin became the law, it was a landmark case because it resolved any number of problems that were previously problems and lent themselves to inconsistent results. So the most important thing about Griffin is that an injury is one of the states that an injury occurred on the employer's premises is universally compensable as a matter of law, very few exceptions. That sets the stage. The court also goes on to say that, as it's closing, and it's a reason, that the existence or absence of a special hazard on the employment present premises is wholly irrelevant to the analysis of an on-site injury. As mentioned previously, a hazard on the employment premises is by definition unique to its sites. I believe that Grafton would have us believe that this is something that could happen outside of work. But this is a prison, and this is a corrections specialist who is also certainly a woman in the presence of men who who are not necessarily in their cells. So there's more to keep an eye on than just traversing the reentry room. There's also the opportunity for prisoners to be within a proximity, not apparently in this day, but that's also something that has to be taken into consideration, because this is not something that a hazard, so to speak, that the public would be exposed to. So I think that's very important, because that's, I think, the consideration in language that the hazard on the employment premises is by definition unique to its situs. Littlefield has no application because that's outside of the premises, and that has to do with the going and coming rule, and the law is very careful not to open the floodgates when it comes to going to coming to employment, because that's largely personal. There's been a lot of discussion this morning brought up by Grafton, which begins to kind of hedge on negligence principles. It's very important to remember that when the Act was passed in 1911, an injured worker did not have to establish negligence. But the injured worker is not expected to establish if there's no negligence, but I still would be entitled to recover. That's what I think the Grafton hedging its argument, and I think that that's really inappropriate, because negligence does not come into play. We can't have it both ways. To Martin versus Wheeler, yes, decided by this court, very interesting case. The problem is Mr. Wheeler was not performing the work purpose when he went out to his CJ7G to investigate, and he saw that the window was broken, the mirror was broken. He tried to adjust it, lacerated his finger, and workers' comp case was filed.
Well, I think the argument on behalf of Grafton is not that the work purpose part goes to the other element and not the arising out of causal element. Because the trial court, when the trial court entered its conclusory paragraph, says by performing her job duties, Vega was working for the benefit of her employer. As such, there is a causal connection between Vega's employment and the injury. But I think the argument, and I'm sure I'll be corrected if I'm incorrect, is sure, that doesn't go to whether or not it was rising, the causal element that is needs to be made in terms of the arising out of. That it only goes to the time, place, circumstances, and initial element that needs to be satisfied.
I understand. A number of cases set by the court which begins to look at what arising out of means. And I'm sorry I don't have the site immediately, but the one where the individual was actually getting up from a crouching position, hurts his knee. And the court in that particular case found that to be compensable. Another one where they said the person was just merely turning and handing something to someone and developed low back pain. But yes, walking is walking, but at the same time, stumbling is stumbling and falling is falling. So there's no question that there was an injury in the course of her employment and carrying out her purpose. And under the Griffin rule, does not need to establish that there was something on the floor, something not on the floor. It says in White versus Buhner, the court concluded that getting into that analysis begins to devolve into the negligence principles and not necessary. But one thing I did address, which I think is important, when there is one element that's actually disputed, and I'm not understanding this morning because Grafton has always maintained that Nancy Vega tripped over her own feet. This morning I hear that Grafton believes that she caught her toe, which is what her testimony was. Well, tripping over your own feet and catching your toe is slightly different, but the court noted, really don't have to get that far, because based upon the prevailing law, it happened at work in the middle of carrying out a job, a work purpose, and greatly simplified the analysis, because whether it was one or the other, the court still found, after thorough analysis, by the way, of arising out and the history of that development, So again, this whole notion that there has to be a risk, a hazard, or something wrong necessarily doesn't really enter into the mix, because Griffin is the hallmark case, or landmark case, excuse me, which kind of clarified all this area of the law and simplified it and brought down to earth, everything down to earth, and pointed out that a hazard on the employment premises is by definition unique to its situs. And so we don't even really get into an analysis as to what that is. Lastly, I did want to touch upon the second issue of error, and that was the diagnosis. And there were two diagnoses advanced by the trial court. One was the compound fracture of the shoulder, and the other one was right rotator cuff tear, which was incidental finding during the surgery. There's no dispute as to whether that was work-related by the parties. It clearly is not, never contemplated. And although we had actually entered into a stipulation saying that the industrial commission can refine what the diagnosis is, well, the Vega case says we cannot. So I believe that this is more easily resolved by this returning to the industrial commission if this trial court decision is affirmed. And that becomes the decision of the commission. And 4123.52 speaks to the industrial commission's inherent continuing jurisdiction. It can be addressed by a stipulation. So that would be the only thing I think is a particular wrinkle, but I think it's otherwise can be addressed between the parties by virtue of that case, and that under 4123.512G, that can be addressed back to the commission. I think that's it. Thank you very much.
Just a couple of issues. I did go back when Mr. Winsick was talking and I grabbed the deposition. She testified I was walking at a fast pace. Didn't say she was rushing, didn't say she was running. She then testified, that's on page 23. From 23 to 24, I asked her if there was something of concern that made her feel there was a safety risk. She had to get this email to somebody. She said no, she just wanted to get back and do her job. I don't think that creates a genuine issue, whether she's walking or walking fast. I don't think that changes the analysis. She still has to meet the second element, the arising out of element. And as I listen to Mr. Winsick's argument, I'm concerned that if this court affirms the trial court, we are effectively eliminating the arising out of element. 4123.01C clearly has two different elements in the course of and arising out of, and our discussion today shows they are very blurred at times. But they are distinct and separate elements.
And that's what I was gonna say. You know, it seems like the courts have moved away from, after Griffin, this special hazard, and not even really required a hazard. They say more like performance of her job duties led to her injury. You're not disputing that it's the performance of her job duties that led to her injury, right?
I'm not, but I'm saying that falls under the time, place, circumstances aspect. I think this court in Market made that very clear when it said there has to be a risk or a hazard associated with the employment. And you're, again, we're blurring these together and merging them.
And I do agree the courts do blur them, but I'm just concerned too, when you're concerned about making the employer universally responsible, I'm concerned over every injury being microscopically, reviewed so that,
It's a slippery slope either way, Your Honor.
yeah, because I think all the times I'm going out to court and I've run into my desk. Okay, I've only bruised myself, but what if one day I fracture a bone right into my desk? So that's not workers' comp?
I don't know, and they're all very fact specific, and I think that's exactly the point with the Tamarkin case. I'm not arguing that jumping over a fence to go to a Jeep, that's a whole different set of circumstances. What we have to do is we have to take the rules of law and apply them to the facts of each case. And I think the further we go, the more we blur the two requirements of 4123.01C, and we're just making one aspect of Time, place, location. Your work doing your job duties, okay, we're gonna eschew the rest of it. And that's not what the statute says. The statute has two very distinct and separate requirements. And every tort, going back to Demarkin, when you talk about arising out of, it talks about the hazard or risk of the employment. It's not just being at work during work hours and doing something that your job requires. It requires more than that, and that's the arising out of it. It requires that risk or hazard. And that's why we think the trial court was too narrow. It says the words, but when you look at and you analyze the result of the trial court, really what it's saying is time, place, and circumstance. Never addresses, never analyzes what the risk or hazard was. And again, I don't want to get into semantics, but the video is very clear. She tripped over her own feet, caught her toe, however we want to say it. There was no substance on the floor, there was nothing there. It's unfortunate.
I'm just struggling with the negligence aspect of it, because it does seem like you're arguing if the employer's not negligent.
Wow.
And let me just say this,
I'm sorry.
your time is up, no, that's fine. Please answer Judge Carr's
Yeah.
question, and then please conclude that.
I'm not arguing negligence, I'm really not. I'm trying to take the rule of law from Demarkin that says there has to be, for the arising out of element, there has to be a risk or a hazard. I'm not saying we're negligent in doing anything, or we weren't negligent in doing anything. I'm just saying, looking at the totality of the circumstances, putting Ms. Vega on April 26, 2022, walking through the reentry room, time, place, and circumstance are clearly met. Now let's go to the second prong of 412301C, which says it has to arise out of, which has been determined by this court to mean a hazard or a risk. There is no hazard, there is no risk. It's almost like an idiopathic. She didn't lift her leg up enough to not catch her toe. I mean, Waller talks about risks associated with the employment versus risks associated just with the injured worker versus neutral risk. This, in neutral risk, there is an unexplained fall. We don't have an unexplained fall. She caught her foot.
And
So
you
I-
answered my question, that's why I know you're out of time.
Thank you. The court will take the matter under advisement and issue a decision in due course. When we make that decision, it'll be leaked to you or mailed to you on the day to wait by the clerk of courts. It